I've committed no violation. You have no lawful basis for this stop.
I'm not asking twice.
She was right. 14 months later, 2 federal careers were over. A civil settlement reached $1.8 million, and 47 people sat in a courthouse that morning waiting for a hearing that never came because the judge was in handcuffs at a gas station. Before we go any further, if you believe every American deserves to be treated by the law, not above it, hit subscribe right now. These stories only travel as far as you carry them. Her name was Diana Okafor, 59 years old, 14 years on the federal bench, Northern District. Before that, 9 years teaching constitutional law at Georgetown. She had presided over more than 400 cases. Immigration law, civil rights, Fourth Amendment disputes. She had written the rulings that other judges cited. Wednesday morning, ordinary in every way. She pulled into the Shell station on Riverside Boulevard at 7:45. Vest pressed, briefcase on the passenger seat. She had a session opening at 9. 47 people with immigration cases pending, their futures sitting in folders inside that briefcase. She filled the tank. She replaced the nozzle. She had done this same thing at this same station dozens of times. The attendant inside knew her face. That's when the unmarked SUV pulled up behind her and blocked the exit. Agent Derek Holloway, 7 years with ICE, 34 years old. He had filed 5 prior complaints against him for unlawful stops. Not one had been fully investigated. He operated on instinct. He trusted that instinct completely. Agent Sean Pratt, 4 years in, 31. He followed Holloway's lead. He had learned early not to ask questions. They climbed out in tactical vests, ICE printed across the chest. Holloway approached her door. Pratt moved around to the passenger side, peering through the glass. This stretch of Riverside Holloway had labeled in his own words a hot zone, a residential street, middle-class neighborhood, coffee shops and dry cleaners. But he had a category for it, and the category was all he needed. He saw a black woman, alone, professional attire. That was enough. It was not enough. She held the credentials up again. Steady hand, clear light. The holographic seal caught the morning sun. Holloway looked at the card the way a man looks at something he has already decided not to believe. Fake. Anyone can print a card. She didn't raise her voice. She lowered it. You just looked at federal judicial credentials and dismissed them without verification. What you are doing right now is unlawful detention. I am ordering you to step aside and let me leave. His hand moved, not to his weapon, to his handcuffs. You're not ordering us to do anything. That was the moment, not the stop, not the demand for ID. That sentence, you're not ordering us to do anything, spoken to a woman who had spent 14 years issuing orders that reshaped lives, that settled constitutional questions that other federal agents were legally bound to follow. She reached into her bag. He tensed. She pulled out her phone. She opened the recording app, held it at shoulder height, and spoke into the microphone with the precision of someone who had spent decades choosing words that would stand up in court. I am Federal Judge Diana Okafor of the Northern District. I am being illegally detained by 2 ICE agents at the Shell station on Riverside Boulevard. The time is 7:51 a.m. I have presented my federal judicial credentials. They have been dismissed without verification. I have committed no violation. I am documenting this stop because it is unconstitutional and because everything said from this point forward is evidence. Holloway's jaw tightened. Turn that off. You're interfering with a federal investigation. She kept the phone exactly where it was. I am the investigation. Pratt moved in from the passenger side. He didn't speak. He positioned himself to cut off the gap between her and the driver's door. A man on the far pump had stopped filling his tank. He was watching. His phone was already in his hand. A woman near the air machine had gone still. She wasn't leaving. Inside the station, the attendant, a man who had seen Judge Okafor fill up at this pump for 3 years, stepped out from behind the register and stood at the glass door. He watched. The Shell station security camera mounted on the canopy column recorded at a fixed wide angle. It covered every pump. It had been recording since the moment that SUV blocked the exit. The ICE vehicle's dashboard camera had been running the entire time. It had captured the approach. It had captured the stop. It had captured everything Holloway said. He didn't know about the man with the phone. He didn't know about the woman near the air machine. He didn't know about the attendant at the door. He didn't know that his own dashboard was building a case against him in real time. He thought he was at a gas station. He was standing in the center of a 360-degree recording. Every angle covered. No gap, no shadow, no version of events that could be adjusted later to fit a different story. 3 people recording, 1 fixed camera overhead, 1 camera in his own vehicle. Pratt moved closer. His face passed directly through the frame of Judge Okafor's phone. She didn't step back. She didn't lower the phone. She had spent her career in rooms where people tried to make her smaller. She had learned a long time ago that composure is not weakness. It is evidence. The trap was already closed. Holloway just hadn't felt it yet. He grabbed her wrist. Not the phone, her wrist. The recording tilted. The frame dropped toward the concrete, the base of a fuel pump, a pair of tactical boots, the undercarriage of her own car. But the audio kept running. It always was. Pratt moved in from the other side. Together they pressed her against the door of her own vehicle. She did not struggle. She did not scream. She spoke. "You are committing multiple federal crimes right now." Her voice was on the recording. Clear, calibrated. The voice of someone who understood exactly what was happening and had already decided how this would end. The handcuffs closed around her wrists. 6 people were watching. The man with the phone was still recording. The woman near the air machine had not moved. The attendant stood in the doorway. A driver who had just pulled in from the boulevard stopped his engine and got out. He didn't understand what he was seeing. He understood that something was wrong. Holloway guided her toward the SUV. A woman in a press suit briefcase still on her passenger seat, hands bound behind her back, being walked across a gas station forecourt on a Wednesday morning. Someone in the small crowd called out asking if she was all right. Pratt told him to back away or face obstruction charges. The man stepped back. He kept recording. The door closed. The SUV pulled out onto Riverside Boulevard. Inside the vehicle, Judge Okafor said nothing. She had done everything she needed to do. She had stated her name, her title, her district, the location, the time, the agent's visible identifications. She had documented the stop from the first demand for ID to the moment the cuffs went on. She had said clearly on the record that federal crimes were being committed. Now she would wait. The drive to the ICE field office took 19 minutes. Holloway and Pratt said very little. Pratt stared out the window for most of it. He knew. He didn't say he knew. But the silence in that vehicle had a different quality than the silence on the forecourt. Something had shifted. She sat in the back seat and thought about 47 people sitting in a courthouse waiting for a hearing that would not happen today. At the field office, they walked her through intake like any other detainee. Agents glanced over briefly and looked away. Pratt logged her into the system name, physical description, location of apprehension. He typed quickly, then they reached the personal belongings. Everything from her bag was laid out on a metal table. Wallet, phone still holding the recording. Lipstick, a folded copy of a motion brief, keys, and then the credentials. Officer Rebecca Patel was the processing agent on duty. She had been with the field office for 9 years. She picked up the judicial ID the way you pick up something unfamiliar, carefully with full attention. She turned it over. She studied the holographic seal. She checked the embedded security chip. She examined the weight of the card, the texture of the surface, the federal court seal pressed into the laminate. She looked at Judge Okafor. She looked at Holloway. She looked back at the card. She opened her computer. She typed a name into the Federal Judiciary Directory. The results loaded in under 30 seconds. The photograph matched. The biography matched. Northern District appointment, Senate confirmation, 14 years of rulings, decisions, precedents, all of it public record, all of it verifiable, and all of it right there on a government website that anyone in the country could access for free. Patel stood up slowly. She didn't knock on the director's door. She opened it. Director Nathan Cross looked up from his desk, irritated at the interruption. She said 4 words. "We have a problem." Cross pulled up the same directory on his own screen. He called the courthouse directly. Yes, they confirmed. Judge Okafor was scheduled to be on the bench at 9. She had not arrived. He read the arrest report. No warrant, no probable cause, no specific articulable facts supporting reasonable suspicion. Just two agents at a gas station and a black woman who had asked the wrong questions. He picked up the phone. "Get me legal counsel right now." Then he walked to the processing room. He looked at Holloway. He looked at Pratt. Then he looked at Judge Okafor sitting in a plastic chair with her hands in her lap, composed in a way that made the room feel smaller around everyone else in it. His voice was quiet. It didn't need to be loud. "Release her. Remove the handcuffs. Return everything, and nobody says a word to anyone until counsel arrives." The handcuffs came off at 10:14 a.m. She rubbed her wrists. She collected her belongings from the metal table, methodically checking each item, making sure the phone with its 23 minutes of audio was still in her hand. Then she walked toward the exit without looking back at Holloway or Pratt. She paused at the door. She turned. "You'll be hearing from me again. In court." The door closed behind her with a soft click. It was quieter than a slam. It landed harder than one. By noon, her attorney had filed a formal notice of intent. By 3 p.m., the Department of Justice had opened a preliminary inquiry. By that evening, the Inspector General for Homeland Security had assigned investigators. The Chief Judge of the district issued a written statement expressing what he called grave institutional concern and demanding a full accounting from the agency within 72 hours. 48 hours. That was all it took for the machinery to begin its work. When you arrest the wrong person, or more precisely, when you arrest someone with the platform and the knowledge to make the machinery move, it moves fast. The civil rights lawsuit followed. Judge Okafor's attorney filed a comprehensive complaint in federal court, naming Holloway and Pratt, individually naming ICE as an agency, and naming the Department of Homeland Security. The damages sought were substantial, but the complaint made something clear from the first paragraph. This was not primarily about money. It was about a record. And the record, once investigators began pulling it, told a story that went far beyond one Wednesday morning. Derek Holloway had 5 prior complaints filed against him. 5. Unlawful stops, failure to verify identity, detaining individuals without articulable cause. 5 separate occasions when someone had formally reported that this agent had stopped them without legal basis. Not one of those complaints had resulted in disciplinary action. Not one had triggered a pattern review. Not one had produced so much as a written warning in his personnel file. They had been received logged marked as reviewed and buried. The system that was supposed to catch exactly this kind of behavior had looked at the evidence 5 times and chosen to look away. This was not a mistake. A mistake is something that happens once that surprises the person who makes it, that produces some form of correction. What Holloway had done was a habit, and the agency had funded that habit with its silence. When Director Cross read the full complaint and saw the 5 prior cases laid out in sequence, he later told investigators he felt the floor shift beneath him. He had signed off on Holloway's last performance review, satisfactory across all categories. Holloway and Pratt were suspended without pay. Badges surrendered. Firearms surrendered. Cross sat in his office and told his legal counsel the same thing the legal counsel had already concluded. This case was indefensible. The 2 agents responded to that reality in entirely different ways. Pratt was realistic. He understood what the dashboard footage showed. He understood what Judge Okafor's recording captured. He understood that going to trial meant a jury watching him press a federal judge against her own car in front of 6 witnesses. His attorney negotiated a plea agreement, 1 count of deprivation of rights under color of law. In exchange for his cooperation and testimony, prosecutors would recommend probation over prison time. He took the deal. He stood in federal court to enter his guilty plea. The courtroom was 2 floors below Judge Okafor's chambers. He stated clearly that he had participated in an unlawful stop and arrest. He acknowledged that he had violated her constitutional rights. He accepted responsibility. The presiding judge asked if anyone had forced or coerced the plea. Pratt said no. Holloway watched all of this and refused to move. His first attorney told him the evidence was overwhelming. Holloway fired him. His second attorney told him the same thing. Holloway told him he would take his chances with a jury. He believed that 12 ordinary people would understand he was doing his job, following his training, enforcing federal law. He believed that the uniform still meant something in that room. His attorney knew better. But you cannot force a man to see clearly when his entire identity depends on the blur. 5 complaints. 5 times someone said this man does not follow the law. 5 times the system replied that it would look into the matter. 5 times nothing changed. Drop a comment right now. Should that record alone have ended his career before that Wednesday morning ever happened? 5 complaints, not one consequence. Tell me what you think that says about the system that kept him on the street. The trial began 6 months after the arrest. The courtroom was full, local press in the gallery, civil rights observers along the back wall, federal employees who had taken personal days to be there. The case had traveled through the legal community the way a fire travels through dry grass fast and without asking permission. The prosecution's opening statement took 31 minutes. They did not sensationalize. They did not need to. They simply walked the jury through the morning in sequence. A woman stopped without cause. Credentials dismissed without verification. An arrest made without a warrant, without probable cause, without a single articulable fact that met the legal threshold for detention. Then they rolled the footage. The dashboard camera from the ICE vehicle ran on a large monitor at the front of the courtroom. Every juror watched Holloway approach the pump. Every juror watched him receive the federal judicial credentials. Every juror watched him hold them for under 2 seconds and hand them back. The prosecutor paused the tape at that moment. She asked the jury to look at what they were seeing. A man holding the identification of a sitting federal judge identification with a holographic seal, an embedded security chip, and a federal court seal that was publicly verifiable in 30 seconds on any device with internet access. A man who had 7 years of federal law enforcement experience. And what he chose to do with that identification was hand it back and say the words that doesn't mean anything. The cross-examination of Holloway came later. He had insisted on taking the stand. His attorney had advised against it every single day leading up to the trial. Holloway believed he could explain himself to a jury. He believed his experience and his badge would translate into the room. They did not translate. The prosecutor asked him a series of questions with the steady patience of someone who already knows every answer. Did you call the courthouse to verify Judge Okafor's identity before making the arrest? No. Did you run her credentials through any verification system? None. Did you consult a supervisor before placing her in handcuffs? Number. Did Judge Okafor commit any traffic violation that justified the initial stop? A long pause. No. Did she commit any criminal act of any kind that you personally witnessed? Another pause. No. So what was the basis for the stop? He said it was her presence in a high-traffic area for undocumented individuals. The prosecutor asked him to describe the location. He struggled. A residential street, middle-class neighborhood, a gas station with a coffee shop attached. She asked what specifically about Judge Okafor's behavior, independent of her appearance, triggered reasonable suspicion. He had no answer that held. By the time the cross-examination ended, the jury had watched a man with 7 years of federal experience admit answer by answer that he had stopped. A woman dismissed her credentials and placed her in handcuffs based on nothing he could legally defend. The only factor he had not named, the one that was visible in every frame of that dashboard footage, was the one that explained everything. The jury deliberated for 4 hours, guilty on both counts. Deprivation of rights under color of law, filing false statements in official reports. Holloway stood motionless as the verdicts were read. His attorney placed a hand on his shoulder. He didn't react. Sentencing came 2 months later. Judge Okafor submitted a victim impact statement. The presiding judge read it aloud in full. She wrote about the lasting weight of being treated as a threat in her own community. She wrote about the anxiety she still felt during any interaction with law enforcement, and she was a federal judge who understood the system better than almost anyone in the country. She asked the court to consider what that moment felt like for someone without her knowledge, her resources, her position. How many others had Holloway stopped who never got a hearing, who never got a record, who just absorbed it and went home? The sentence was 30 months in federal prison, a $50,000 fine, restitution for attorney fees, pension forfeited, federal conviction, permanent record, career in law enforcement finished. Federal marshals placed the handcuffs on his wrists in open court, the same model he had used that morning at the Shell station. The symmetry was not lost on anyone in that room. It was not lost on anyone watching. The civil settlement reached $1.8 million. But that number, large as it was not the part of this story that stayed with people. Judge Okafor donated $3 million to organizations working on criminal justice reform. She used $1 million to establish a legal defense fund specifically for people who could not afford attorneys when challenging unlawful arrests. She kept the remainder not because she needed it, but because accepting it meant the agency formally acknowledged what they had done to her. The money was accountability made tangible. She returned to the bench 6 months after the settlement. Some questioned whether the experience would make her less impartial in cases involving law enforcement testimony. She answered that question the only way it can honestly be answered, through her rulings. She convicted when the evidence warranted it. She acquitted when it did not. She held officers accountable when they lied and credited them when they told the truth. 47 people had waited in a courthouse the morning she was arrested. Their cases were rescheduled. Their lives kept moving. She made sure she was there for every hearing that followed. She still drives past the Shell station on Riverside Boulevard every morning. She does not take a different route. She does not avoid that corner or the memory attached to it. She said it once in an interview when a reporter asked if she thought anything good had come from what happened to her. She considered the question for a long time before answering. That corner doesn't own me. She kept driving exactly where she needed to go. If that kind of accountability matters to you, the kind that doesn't stop at one verdict, that uses the settlement to protect the next person, that refuses to let fear reroute a single morning, share this video. Like it. Subscribe. Because these stories deserve to reach more than the people who already know them. The ones who need to hear it most are the ones who haven't yet.